I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have interesting cases and good lawyers. We're looking forward to it. In the first case, the County Commission of Fayette County against National Grid et al., Mr. Callahan. Good to see you, Mr. Callahan.
Good to see you, Your Honor. Thank you so much. And may it please the court, my name is Michael Callahan. I represent the Fayette County Commission of West Virginia in this case. Simply put, this case is about Fayette County's efforts to clean up mine waste left by coal companies over the years in West Virginia. Fayette County's in a unique place to do that. It has a national park within its borders, and Fayette County is set out to try and eliminate acid mine drainage within its borders. Now, I will tell you the court, these are called gob piles, garbage of bituminous. They emit acid mine drainage, they ruin streams, they drop pH, they kill fish. These are environmental problems left by coal companies in the 50s and forward who left this mess for the state or the county to try and clean up. And no, unlike the appellees argue, this is not rock on top of a hill. This is exposed mining waste, which includes coal, coal waste, and other things where the rain hits it, picks up all of these contaminants, iron, manganese, arsenic, low pH, high conductivity, and it flows into the creeks of West Virginia. Fayette County is a West Virginia political subdivision which has been granted the full police powers of the sovereign state of West Virginia to abate public nuisances within that county. That is a fact I submit to you was ignored by the district court on day one. And I have 3 points.
Are you talking about the ordinance that you adopted?
Yes, Your Honor.
And what the effect of it is?
Yes, Your Honor.
Is it your position that Fayette County can declare what a public nuisance is?
Yes, Your Honor.
But doesn't that run contrary to Supreme Court precedent in West Virginia?
I don't think so, and we'll address the details of the Parker and the other decision, Sharon Steele, in just a minute, but let me start off on a higher level if I could. The two statutes, 713KK and FF, both of those statutes grant Fayette County the authority to abate public nuisances.
You say you call them statutes, they're Fayette County ordinances?
Ordinances, no, let me back up. West Virginia statutes grant to Fayette County the ability to issue ordinances and do things.
Okay.
And those two statutes, West Virginia Code.
That was the legislature of West Virginia conveyed that to the, or delegated that or assigned that to Fayette County?
That's correct. And if you read those two statutes, the legislature used words like plenary, all right? I had to really study on that word, but that's pretty much an absolute grant of public nuisance abatement authority to the Fayette County.
Plenary authority, you say?
Pardon?
Plenary?
That's what the word is in the statute, Your Honor.
The statute authorizing?
Authorizing Fayette County to enact ordinances. The other statute, it uses the phrase anything, and that's the word in the statute, the West Virginia statute. Anything that Fayette County deems to be a public nuisance, they can abate. Now, I'm not here trying to tell the court that that means Fayette County can pick anything, all right, and decide it's a public nuisance. It has to be rationally related or a rational basis to do so. And where the district court got this wrong from day one, it looked at common law public nuisance as applied between parties. It failed to go back to the statutory grant of authority on KK and FF that I discussed and what that authority was to the County Commission of West Virginia. Now, I'm not going to tell anyone the court doesn't have review authority over what the County Commission does, but it certainly does not sit as a super legislature or a legislative body as the court did in this case. Let me give you an example. If the Fayette County Commission comes in and let's just say one of the commissioners, her husband ran off with another woman in a green truck. I drive a green truck. Well, if that commissioner proposes an ordinance that says all green trucks are banned in Fayette County, well, that's silly. And that violates due process, constitutional provisions, and a whole bunch of other things. So there has to be some rational basis, and the district court did not follow.
What case are you getting that from, that it says it has to be some rational basis of relation? Your rational basis standard that you,
Well, I'm talking general substantive and procedural due process.
yes, but I'm asking where are you getting the rational?
There are many Supreme Court cases that say a legislation, when it's enacted, it has to form a rational basis as to protecting the public. I can't give you a cite off the top of my head. But the concept is the Fayette County Commissioners are elected, and I'll go about 10 seconds or 20 over if I may. The Fayette County Commission, they are elected people. The citizens of Fayette County puts them in their spot to be commissioners. They decide what is an acceptable risk within Fayette County. And that acceptable risk should be constitutionally accepted so long as it passes due process provisions as enumerated by our Supreme Court.
Let me ask you something.
Sure.
Sit down. As long as you get questions, you keep answering them.
Okay.
Is a violation of a state criminal law per se a public nuisance?
I would argue that it is, yes.
Is a violation of the federal criminal law a public nuisance in Fayette County?
In the context of the
West
court,
Virginia.
yes, yes.
You'd say a violation, I meant criminal, did I say criminal law? A violation of a criminal law is automatically or per se a public nuisance.
Under the ordinance, we would have to come to court to prove that, but yes, it would be a per se public nuisance.
Okay, but you have any cases directly on point that say that?
I do not.
Okay.
Can I ask you one more
Yes.
question before you sit down?
Yes.
On this question, is there any distinction between the ordinance and what it covers and the other claims that you brought? The district court said that these are like dominoes, and it said, well, the federal claim fails, the common law public nuisance claim fails, the West Virginia statute claim fails, and those are the same sorts of obligations that the ordinance covers. Therefore, the ordinance claim fails. And in your brief, I was looking for a distinction that you were going to draw between, no, the ordinance would prohibit other things, and that's what this is about, but I didn't see any distinction being drawn between the ordinance, what the ordinance covers, and what these other claims cover. But I wanted to give you a chance to address that.
Well, we attempted to address that in one of the sections of the brief where we talk about the provisions of the ordinance that we were relying on in this case.
Mm-hmm.
But to answer your question broader, where the district court got it wrong, it is the same with the RCRA statute, the ordinance, and public nuisance. The district court in its very first order said the county is tasked with the burden of proving harm. And if you look in some of the orders, the district court says, well, the county was foolish or frivolous in bringing this because we didn't show a statutory or an environmental quality violation. Well, that's not the standard for public nuisance. Imagine driving down a West Virginia road and you see tires and refrigerators on the side of the road. You know that's an open dump, you know that's a public nuisance, and you know it should be fixed. The question is not, is that leachating into the environment causing harm? It's an eyesore.
Well, I guess,
An eyesore is a nuisance?
It is, Your Honor. An eyesore that causes potential harm to the public.
so my question is, do you have, if your federal claim, if your RCRA claim fails, if your West Virginia statutory claim fails, if your common law nuisance claim fails, is there any argument that the ordinance independently can support this lawsuit?
Yes.
And what is that?
That argument is the Fayette County Commission was delegated the authority.
I get that. What part of the ordinance specifically is different than all those other legal obligations?
All right, so I'll cite for the court sections 5B, 5A10, and it declares any act or commission or omission and any condition which constitutes a nuisance by statute or common law of West Virginia when committed, omitted, or existing within Fayette County is declared to constitute a public nuisance.
Well, that seems to wrap in the common law, which if you don't have a common law claim, that wouldn't work. And a statutory claim, if you don't have a statutory claim, that doesn't work. So
Right.
how is the ordinance on its own, independent of these other legal obligations? Even if, say I assume the commission has the right to make the ordinance broader than federal law, state law, and common law, but what specific provision of the ordinance applies here that would continue to be valid if these other bases for your claim fail?
When, I guess I come back to the core argument, when the commission was giving the authority to address what is a public nuisance, an elected body decided.
Yeah, I'm assuming, I don't want to keep you, I know you have a co-counsel who wants to come up, but I'm assuming the commission has that authority. The commission can enact an ordinance that's broader than federal law, broader than state law, broader than what the common law would normally call a nuisance. What I'm looking for is what is the provision of the ordinance that you think is violated here that is different from the common law, federal law, and state law, that if all those claims fail, the ordinance still independently supports liability here?
Well, we have pled, and there's a whole list of things that the Fayette County Commission said were a public nuisance within Fayette County. And my co-counsel can probably address that better than I
Okay,
can.
sorry.
And
I didn't know if you were like, this was like your issue and not his, but you come on up and we'll talk about it.
I was going to move on to the Corcus issue, but these are more important issues, I think, and it's the core of our case. So let me defer to my co-counsel.
Mr. Donovan?
Thank you, Your Honor. May it please the court, Michael Donovan, Assistant Fayette County Prosecuting Attorney representing the County Commission of Fayette County. I'm going to address the very question that the judge was posing to Mr. Callahan. At the predicate of this case, the very beginning of this case, Your Honor, the fundamental error here was a failure to recognize the difference between the application of the public nuisance doctrine by a court and by a legislative body. In West Virginia, the West Virginia legislature derives its authority, and it is plenary as a sovereign to do anything it determines necessary to provide adequate protection to the public. That's based on the 3 sections of the Constitution that say the citizens of West Virginia are the sovereign of the state. They form the government for the purpose of protecting the public and protecting the common welfare, and they delegate all of their authority to achieve protection of the public to their elected representatives. Those are cited in our brief. That's where the sovereign state of West Virginia gets its authority under the public nuisance doctrine, not from the common law, from the Constitution of the state of West Virginia. In section 713 KK of the West Virginia Code, the West Virginia legislature, for the first time in its history, it had previously, 100 years before, delegated some limited public nuisance authority to municipalities. But for the first time in its history, it delegated in the late 1980s and 1989 and 1990 authority to county commissions. And it gave plenary authority, the authority to adopt ordinances, the authority to declare anything which the county commission determines to be a public nuisance may be abated as a public nuisance. It gave the counties power that it never gave municipalities, the power to issue orders as necessary and to take any other action necessary or appropriate in the view of the county commission to abate a public nuisance. The answer to Your Honor's question is straightforward. In its adopting its ordinance, Fayette County was posed with a question, because there are 2 statutes that grant to the county abatement authority over public nuisances. One is 713 FF, which is the earlier statute, and it addresses a very, very limited set of public nuisances. on private land that affect only private land. And it's a subsection of the statute that addresses dilapidated properties. Subsection B of that statute addresses accumulations of refuse or debris on private property. And there's a whole procedure set up where the actual complaints are filed before the commission, decided by the commission, and then you take a record appeal if you want to the circuit court, but it's on the record. That FF provision is a very limited issue. That is public nuisances that affect only private land. And it says so both in the title of the ordinance and 4 times in the statute itself, on private property. Years later, they
Is your
enacted...
position that the Fayette County Commission can expand what a public nuisance is in West Virginia?
Yes, and they may
For the
declare...
purposes- For purposes of Fayette County alone?
That's absolutely correct, Your Honor.
So it could be a public nuisance in Fayette County under your ordinance, but not be a public nuisance in Kanawha County down the road?
Precisely. 48 of 50 states, Your Honor, and in the survey done, and it's cited in our brief in a footnote, done by the National Association of Attorneys General, it is a prevalent thing in the states to prefer the exercise of public nuisance authority at the local level of government. 48 of the 50 states delegate broad public nuisance authorities to local levels of government. In West Virginia, as I said, that was done to cities in 1898 and again in 1913. In delegating it to counties is much broader and more powerful and much more recent. And it's the ability to abate anything which the county commission determines to be a public nuisance. And that statement, anything which the county commission, is a statement not only of what they're conveying to the county commission, but it also gives this court a clear statement of what the West Virginia legislature considers to be its authority. And they are correct. As the legislature has the authority...
Can I ask you, just to follow up on my question to your co-counsel,
Where in the ordinance do they do that?
well, let's just assume for a minute that you're right about that the commission can enact an ordinance that reaches broader than the common law. If, again, totally assume that the district court was right about federal law, that there was no violation of health or environmental quality in the water, there was no contribution to, et cetera, et cetera. The court was right about federal law, it was right about that there's no common law public nuisance, it was right under the West Virginia statute that all those claims fail because there's been no proof of a violation. Does the ordinance have some independent obligation, different from all those obligations, that still has been violated, and what is it?
Precisely, and the answer is yes, it does, Your Honor. They have the authority to do it, and they did do it in Section 5A, 5, 10, 17, and B. So 5A, 5A5, 5A 17, 5A 10, and 5B of the ordinance. And in particular, I'll address now the precise answer to your question in section...
Well, 5A5 is imminent and substantial endangerment to public health or the environment. That seems to have been covered already by the RCRA ruling.
No, Your Honor. May I direct the court's attention to the last phrase in that section with following the word "or."
Impairs beneficial uses.
That's right.
Where in your brief can I find an argument about how the court was wrong by not addressing whether this impairs beneficial uses?
Consumes the last 14 pages of our, last 4 pages, I beg your pardon, of our motion for summary judgment, and the last 3 pages of our reply in that case. But most importantly, I would direct the court...
Your brief's on appeal? Do you make an argument about this on appeal?
Yes, we did, Your Honor. And the point is, we argued is twofold. Your question asks me to assume that there is no common law public nuisance. We do not agree with that.
I know.
But assuming that to be true, we have proved, and I would direct the court to paragraphs 23 through 21 through 33 of Dr. Simonton's affidavit attached to our reply brief before the trial court in the motion for summary judgment. He demonstrates clearly that there are adverse impacts to the beneficial uses of those waters because they stress fish, and it stresses and deprives the water of providing beneficial uses to aquatic life, both macroinvertebrate and fish. Concentrations of arsenic and conductivity in the water are from 33 times what it is before the mining lease.
Is this disputing the district court's RCRA ruling about what the tests of the water show? The court said there's no danger to health or in the environment.
Does it dispute it? Yes, in fact, it does. But it also goes to the point, is there an impairment of the beneficial uses of the water? That's a different question. The district court was focused entirely on harm. That was its issue. Where is harm? And it determined harm entirely by numerical standards, and that is absolutely incorrect. The narrative water quality standards in West Virginia are enforceable conditions of its Water Pollution Control Act, but more importantly, as a concept, the narrative standards for water quality in West Virginia provide that you cannot impair the beneficial uses of water. It's that very concept what the Fayette County Commission adopted and then put into its own ordinance, and says, if you discharge any waste in Fayette County that impairs the beneficial use of the waters within Fayette County, then that's a public nuisance in Fayette County. And we have clearly established, in this case, we clearly established that there were violations of the narrative water quality standards of West Virginia, and there are impairments to the beneficial uses of those waters within Fayette County, which the ordinance expressly declares to be a public nuisance in Fayette County, regardless of any actual harm. You don't need dead fish, or you don't need to exceed some numerical water quality standard. You just need to demonstrate that the beneficial uses of those waters, which is to support life, health.
Do you have any authority to support your theory that aesthetic harm is substantial harm?
I'm sorry. Your Honor.
What authority do you have that supports your position that aesthetic harm is substantial harm? What cases, do you have any cases that support your theory regarding the aesthetic harm?
I don't think we argued any purely aesthetic harm, no, Your Honor.
Well, you're saying the fish don't have to die, it's just that the waters are, because of the water, the argument that you were just,
No, I beg your pardon, that's beneficial uses. They are established scientific criteria that tell you when, for instance, may I quote from the affidavit, the declaration?
I guess what I'm asking is what case do you have to support that?
Case.
Do you have any cases to support your argument?
Your Honor, there are many cases, and I can't quote them to you right now, but there are many cases that hold that narrative water quality standards under the federal and state water pollution control acts are enforceable. Not just the numerical standards, but the narrative standard. And the narrative standard is you may not put wastes or discharges into water which impairs the beneficial uses of those waters. And one of the beneficial uses of the water is that it supports, without stressing, fish, wildlife, and macroinvertebrates that keep the ecosystem healthy. When there are no measurable tests for deciding when you have put enough waste in the water that it impairs that use, that beneficial use. These are called...
The waste you're putting in there, we're talking about these 5 gob piles.
Yes.
It's basically runoff.
Acid mine drainage, yes, Your Honor.
Well, runoff when it rains.
It's rain precipitating through coal waste.
And it runs into the stream, which runs into the Kanawha River.
Precisely, but also runs into the groundwater. It runs into the groundwater and surface waters, and then eventually makes its way to the larger river, right?
Can you do that passively, or they have to show some active?
No. For instance, Your Honor, let me...
What can you rely on to get to where you're going?
The ordinances...
Can you rely on a violation of a misdemeanor violation of state law?
You don't need a criminal violation at all.
You don't rely on that?
No.
Can you rely on a misdemeanor violation of the federal law?
Not at all.
You don't?
You don't need it
You
at
ever heard of
all.
the Refuge Act?
No, you don't. That's not required either.
Have you ever heard of the Refuge Act?
Of course, Your Honor, yes.
A
Both the
refu-
33 and 38 Refuse Act, yes, Your Honor.
of the Refuse Act of 1899.
And last amended by Congress in 1934, right? And the Refuse Acts preceded the adoption of the Clean Water Act in 1969 and again in 1970.
But the Refuse Act is still on the books.
It is, in fact, still on the books, Your Honor. And that Refuse Act prevents the placing of waste in a location where it may enter into waters of the United States. That is a separate criminal issue. It's a civil and criminal issue under the federal
That's
code.
but I asked Mr. Callahan,
I beg your
is a
pardon?
violation of the federal criminal law or the state criminal law a nuisance per se in West Virginia?
Certain violations of it, yes. Would a
There
violation
is
of-
one.
Is
A
that one?
violation would a violation of the Refuse Act of 1899 constitute a nuisance, public nuisance in West Virginia?
Yes, Your Honor, it would. Because in West Virginia, a public nuisance is anything which operates to the substantial detriment of the public as a whole, and it need not have environmental harm, as the district court says. Instead, it must show that it presents an impairment to the adequate protection of the public, health, safety, welfare, or the environment. And certainly, placing waste in a water system that impairs some of the beneficial uses
Have
of
you
the
ever alleged that in this case, that a violation
Refuse Act.
of the Refuse Act?
We
You
alleged
never
some-
brought that up here,
We did not, but we did allege.
and
Your
it's a misdemeanor,
It is, in fact, a federal
and
misdemeanor.
it's punishable by a fine.
Yes, Your Honor. And that's at federal law. At state law, we did plead and prove the discharge of industrial waste into the waters of the state is prohibited by Section 8 of the West Virginia Water Quality Control Act. The acid mine drainage leachate coming off of those gob piles is an industrial waste as defined by the Clean Water Act, State Clean Water Act in West Virginia, and it's prohibited. You may not place industrial waste in a location where it may enter into waters of the state. It is doing that. We also pled and proved the violation of the groundwater protection rule in West Virginia, which says, and I'll give the court the exact quote, but in the groundwater protection rule in West Virginia provides that you may not place, without a permit, you may not place any waste in a location where it enters into the groundwater in such a manner as to impair the beneficial uses of that groundwater. So this concept of beneficial uses is what I'm saying permeates the whole concept of public nuisance, and it is enforceable under the Clean Water Act as well. You don't need numerical violations. There are numerical standards under the Clean Water Act, and then there are narrative standards, and they're both equally enforceable and equally prohibited. And West Virginia prohibits, and in fact, the Federal Clean Water Act requires them to prohibit any material that impairs the beneficial uses of water. And to respond to the court's question, what impairs the beneficial uses of water is a provable scientific fact. In Dr. Simonton's declaration that I referred you to, the declaration attached to the government's reply brief in the motion for summary judgment, paragraphs 21 through 33 of that will demonstrate where we have proved that those materials being discharged from these gob piles impair the use by stressing macroinvertebrates and fish, causing injury to these animals, to this ecosystem, and the uses of this water for this purpose.
Let us hear from them. You're on the red light, you know that.
Thank you, Your Honor.
And we're giving you extra time, and we'll give them some extra time, too,
Absolutely.
if they need it.
I thank the court for its attention.
But we appreciate it. Good to have you with us. Yes. Mr. Harvey?
Yes, Your Honor. Good morning. May it please the court, my name is Shane Harvey. I am here today on behalf of National Grid. I am fortunate to be joined today by a very good young associate, Mr. Colton Kuntz, who helped with the briefs. We are splitting our time today with Mr. McMillan, who's behind me, and Mr. Harry Lee. I will be addressing the county's arguments with respect to their claims of nuisance and their claims of imminent and substantial endangerment. Mr. McMillan will be addressing the county's arguments, which we did not hear much of today, but in their briefs, about the ownership of these so-called piles of rock, these AML piles, we call them, the county calls them gob
So
piles.
you're the nuisance expert.
I am the nuisance expert, yes, Your Honor, today for the next 13 minutes, yes, sir.
All right.
Yes, sir.
Now, do you think that the violation of a misdemeanor criminal statute in West Virginia is a public nuisance?
I think it could be, Your Honor, if the statute was designed to protect the public from the effects of nuisance-type effects like health or environmental effects. I don't think the violation of a jaywalking statute would be a nuisance per se, Your Honor.
How about a federal violation?
I think the
Violation of federal law, misdemeanor.
I think the answer would be the same, Your Honor. If the federal law was something that protected the public from nuisance-type effects, I think that a county could perhaps point to that as evidence of a nuisance per se.
Are you familiar with the Refuse Act?
I have to admit, Your Honor, I've been doing this for over 30 years, and I am not familiar with the Refuse Act. I heard you and Mr. Donovan talk about it. I get the gist, but I am not
I'm talking about
familiar with it.
it's generally referred to as the Refuse Act of 1899. It's been on the books for
I learned about it for the first time today, Your
a long
Honor.
time. And it says this, it shall not be lawful to throw, discharge, or deposit, or cause, suffer, or procure to be thrown, discharged, or deposited, any refuse matter of any kind or description, whatever, other than that flowing from streets and sewers and passing therefrom in a liquid state into any navigable water of the United States or into any tributary of any navigable water from which the same shall float or be washed in such navigable water. And it goes on. And it's that's 33 USC section 407. And it's been described as a misdemeanor, and it authorizes a fine. And there's a, let's see here. In 1973, the Fourth Circuit, at 480 Fed Second 616, affirmed the conviction of Valley Camp Coal Company for violating the Refuse Act at Shrewsbury on the Kanawha River in a charge that said they threw, discharged, deposited, caused, suffered, etc., refuse matter, to wit, black coal waste matter into an unnamed tributary of the Kanawha River, which floated and washed into the Kanawha River, a navigable water of the United States. And they were convicted by a jury in Charleston. And it was affirmed by the Fourth Circuit Court of Appeals. I've given it to you here. And it's a misdemeanor. And it was called by rainfall. The court says, we reject the contention and hold that a violation of statutory offense described in the first clause of the statute is made out by proof of depositing refuse matter on the shore of a tributary of the navigable river and the subsequent washing of the same by rainfall into the tributary. Affirmed. And it's a misdemeanor was a misdemeanor prosecution, and that's the Refuse Act, which is still on the books, I think.
Your Honor, again, I've never encountered the Refuse Act, but as you describe and read the statute, it does not resemble in any way what we have here. If I could just briefly discuss the facts.
And that had a couple lawyers in it. One represented Valley Camp Coal Company by the name of Thomas Miller, who also happens to be the author of the Sharon Steele case, when he later went on the Supreme Court of West Virginia. And it happened to be prosecuted by, among others, an assistant United States attorney that was me.
It sounds like you did an excellent job, Your Honor.
And it's a published opinion,
Yes, Your Honor.
and it's hardly ever been cited anywhere. And that was in 1973. That's more than 50 years ago. Judge Craven, Judge Butchner, and Judge Russell. And we might have some, that's Judge Craven right over there. And
Your Honor, let me suggest that you would,
I'm not going to charge you for any of that time.
thank you, Your Honor. Thank you very much, Your Honor. Let me suggest that you would not have prosecuted that case at this location.
Pardon?
Let me suggest that you would not have prosecuted that same case at this particular location. If I may, let me tell the court just a little bit about,
I don't know where the records are on this case, where they even, where they keep them when they're more than 50 years old. But I know that I wrote the indictment, and we emphasized the word suffer. They hadn't done anything. Valley Camp said that they hadn't done anything to pollute the river. This was a gob pile. It was a gob pile sitting on the bank of the little tributary up there. You know where Shrewsbury is.
I do, Your Honor.
You know exactly where it is, and I do too. I mean, it's less than 20 miles from Deepwater, where this stream runs into the Kanawha River. But we alleged black coal waste matter. That's what was was running into the river as a result of thunderstorms. They would, the authorities from somebody up the State House, the fellows went up there, and after they had thunderstorms, they would test the water. And we would know what was in there, what the water was before the storm and what it was after the storm. And we had a jury trial. Poor Judge K.K. Hall, he's not in this courtroom, but, yeah, but.
Yes, Your Honor. I imagine in that case that you were trying to abate some sort of harm to the stream. There was black material running in the stream.
I think they were, the state authorities, somebody had brought this to us, and they were wanting to get that gob pile cleaned up.
Yes, Your Honor.
That's what it was.
Let me tell you about.
It was a preparation plant. There was a preparation plant up there.
Yeah.
I mean, it's different than, it's distinguishable from here because it was close to the river there at the preparation plant. And this is somewhere up a creek on the side of the hill, and these five have been there for years, but all that.
Yes, Your Honor. I
It's
imagine.
basically runoff is what this case was.
Yes,
from
Your Honor.
after the thunderstorm.
Yes, I imagine this situation here is much different than the one you were confronted with as a prosecutor.
And I knew you were going to say that, and that's what you have to say.
Well, Your Honor,
Is it what you have to say? Has anyone brought a claim under the Refuse Act here?
no, Your
So
Honor.
you don't have to distinguish this case. You're welcome to distinguish it, but it doesn't seem like you have to, right? Because that's not the law we're talking
I'm trying to
about.
be respectful to Judge King, Your Honor.
Absolutely. I thought that was fascinating. I had no idea. But I'm just saying what you need to do might be
No,
not
there's-
related
there's
to
been-
that.
There's been no claim of nuisance per se here by virtue of violation of the Refuse Act, Your
Okay.
Honor. That's very correct.
No, but the point is, that I knew you were going to say that too. And that's what I was asking Mr. Callahan about, is a misdemeanor criminal violation of the federal law a nuisance in West Virginia or Fayette County? I mean, that's what this Valley Camp case is. Would that be a nuisance?
I think you'd have to have harm, Your Honor, under our law. I think
Okay.
it's,
It has to be harm, under what authority?
I think there are cases in West Virginia that suggests that a mere violation of a statute is insufficient to establish a public nuisance. The statute has to, the conditions on the ground have to actually result in harm. We don't have that here. These piles of rock have seeps flowing from them. The seeps were tested by Dr. Simonton, as the county points out. He did find some level of iron and manganese, beryllium, arsenic, cadmium. He did not find that these materials were present in quantities that exceeded any regulatory standard designed to protect the environment. Mr. Donovan continues to talk about harm and killing fish and impairment. I have no idea what he's talking about, to be frank about it. This water was tested extensively by National Grid during the conduct of this case. National Grid went to these streams on 2 occasions, in the spring and summer of 2022. It conducted sampling up and down the stream at 10 locations. Upstream of these gob piles, as the county refers to them, and downstream of these piles of rock. Here's what was found at these 10 locations. Absolutely no presence of arsenic, beryllium, or cadmium whatsoever. Very low concentrations of iron and manganese, similar to what you might find in West Virginia's most pristine streams. No exceedance whatsoever of any state water quality standards designed to protect streams. No exceedance of any maximum contaminant level under the Resource Conservation and Recovery Act set by EPA to protect the environment. And no exceedance of any health-based standard under the Safe Drinking Water Act. This evidence is uncontroverted. The water in these streams is good. There is no harm. And that is what dooms the county's claims here. There is no harm or risk of harm. The county wants to argue that the district court got it wrong by applying the wrong legal standards to the county's evidence. The county's problem is it lacks any evidence of harm whatsoever, either actual harm or even risk of harm. I see I'm short on time. That is what dooms their claim under the Resource Conservation.
You have some more time. Keep going.
Well, let me proceed then with the Resource Conservation and Recovery Act, which wasn't touched upon earlier by the county. The county suggests that the district court got the standard wrong because it demanded proof of actual harm versus risk of harm. The district court did no such thing. If you read the district court's opinion, it recognized that the RCRA standard is an expansive one. We agree with that. And that is based on risk of harm, not actual harm. The district court uses the word risk throughout its opinion. It did not misapply the endangerment standard. The county's problem, again, is that it cannot even establish risk of harm. The water quality here is good, as we just discussed. There's no violation or any evidence of any possible violation of any environmental standard. On top of that, as the district court found, no one is using the groundwater in this valley, which is an important aspect in endangerment claims, as the district court recognized.
The water that went to the homes came from the New River, as I recall from the briefs here. And this water was flowing to the Kanawha River, this stream.
You have that partly right, Your Honor. Let me try to clarify. Initially, there was a well in the Johnson Fork watershed. The PSD was acquired by another company that came in, West Virginia American Water. You're familiar with them. They began to use as the source of their water from the New River. You are right. The water in this valley flows from Johnson Fork, which we've talked about, to Loop Creek, and then eventually into the Kanawha River.
The Loop Creek gets to the river.
Yes, Your Honor.
To the Kanawha.
Yes, Your Honor.
The Great Kanawha, but the new comes into the Great Kanawha. New forms the Great Kanawha, helps form it.
It gets very confusing down there around the Gully Bridge,
all
Your Honor,
ends
but I
up
think
the
you have
same.
it right. Yes, Your Honor.
And it all goes to the Gulf of Mexico.
Eventually, yes. Mr. Donovan is dying to call it something else, I think, but it's Gulf of Mexico, yes, Your Honor. The lack of harm here is also a problem with the county's common law nuisance claim. As the district court found, if the county cannot establish even a risk of harm for an endangerment claim, they certainly cannot prevail on a common law nuisance claim. That requires evidence of actual harm, a higher threshold. And for that reason, you see the county spend almost no time in its briefing on the common law nuisance argument. It just simply cannot prevail there. Next, the county makes an argument of nuisance per se under the Solid Waste Management Act. And I want to be clear that this is not your typical nuisance per se claim. The county does not allege, for instance, that National Grid violated some regulatory standard under the Solid Waste Management Act. In fact, the county concedes that National Grid is not subject to any regulatory standard under the Solid Waste Management Act because it applies only prospectively. And National Grid's association with the site ended in 1966, well before the Solid Waste Management Act was passed in 1983. What the county claims is something different. It looks at a finding in the statute, Section 1C, where the legislature finds that the improper placement of solid waste is a public nuisance. And the county argues that it can enforce that finding, and not only enforce it, but enforce it retroactively, even though the remainder of the statute applies only prospectively, as the county concedes. That is, the county argues that it can break the statute into two pieces and enforce the legislative findings retroactively, and the rest of the statute would apply only prospectively. There are a couple of problems with this argument, as the judge, as Judge Johnson found. First, Section 1C, the legislative findings, are not an operative part of the statute. The law is very clear in West Virginia and elsewhere on this point. Courts uniformly understand that legislative findings are not an operative part of the statute. They may be used.
You're referring to the preamble
The
issue.
preamble, yes, Your Honor. It is often called that. That type of prefatory language.
And you got a good argument on that.
Thank you, Your Honor. I will move on then to the nuisance per se argument with respect to the county's ordinance, because the court did spend a lot of time.
Can I ask you
Yes,
just
Your-
to
yes, Your
see,
Honor.
to follow up to Judge Rushing's question earlier, is there any way that this ordinance argument survives if you can't show the state statutory common law harm?
I don't think so, Your Honor. Our law on this is very clear, starting over a century ago in the Parker decision and then continuing on with the Sharon Steele decision. The county has to show a nuisance as recognized under established law, and they can't do that, as we've discussed. So under Parker and Sharon Steele, they cannot prevail. I would also point out that this court in the Winder decision, cited in our brief, looked to the Sharon Steele decision in interpreting the very statute that the county relies on here, West Virginia Code 713KK. That is the source of the county's authority that they claim. And the Winder court, this court, in that case, found that Sharon Steele limited the county's authority under that statute. It was limited to abating actual nuisances as recognized under common law or statute, which the county, again, cannot do here. I've lost track of where I am with my time with our discussion
No,
of the
but
Refuse Act.
Mr. Callahan says it's their position that a violation of a federal criminal statute, a misdemeanor violation, is a nuisance. I guess a nuisance per se.
I just don't know what statute that would be in the context of
Well,
this case, Your Honor.
that's what I was getting. I'm talking about the Refuse Act.
Again, Your Honor,
Again, it's a misdemeanor. The first 5 words are, "It shall not be lawful." It shall
again,
not be lawful, and it's been on the books since 1899. And it's there.
yes, Your Honor.
And Valley Camp Coal Company was fined, and that's what the opinion says.
Again, Your Honor, I think.
The district court imposed a fine upon a violation of Section 407 of Title 33.
Yes, Your Honor. As Judge Rushing pointed out, that act was not raised by the county. even as you read.
This
the
hadn't been
refuse
raised
act,
by the county.
It has not been raised by
But
the county.
it's a legal point.
It is, Your Honor.
It's a legal point.
Even as you read the Refuse Act, Your Honor, to me out loud today, it does not
It's
sound.
on the
like-
books.
I don't doubt that. It doesn't sound like it covers the same conditions we
Let
have at
me
this site.
ask you this just in follow-up to
Yes, Your Honor. Yes,
Judge
Judge Richmond.
King's. So has there been any prosecution under the refuge act of anyone that, because I would assume you would have to have the violation first before you could, under the criminal law?
There's been no prosecution of anyone at this site under the Refuse Act. There's been no mention of it until today, Your Honor. The county is not relying on the Refuse Act in this case. If there are no further questions from me,
Thank
I'll
you.
turn it over to Mr. McMillan.
Thank you very much,
Thank you, Your
Mr.
Honor.
Harvey. Good to have you with us.
Thank you.
Mr. McMillan? You're going to explain it all to us.
Yes, sir, I am. Good morning. Good morning. I'm Stuart McMillan. I represent what we refer to as the surface defendants. And one thing I will say, that the reason that we are not liable in this matter,
Who's your client, Mr.?
Party in Quercus,
Okay.
Your Honor, is even if there were some sort of environmental violation, which there is not, we don't have, our property wasn't involved. There's no evidence that there's some sort of environmental issue
You're saying
imminent.
none of these gob piles were on your land?
That is correct. Let me just say this about the gob piles, because I think this image, I've walked through the woods of the gob piles, and I can guarantee you that you would never know that you were walking on a gob pile. It is forested, West Virginia, densely wooded area with a lot of different things going on, but actually it's some sort of giant gob pile. That's not the case at all. I've heard that numerous times throughout the argument. I just want the court, you don't have the luxury of going down to Fayette County and actually walking in the
We used to have
woods.
these gob piles around West Virginia. I can remember driving the highways that stayed on fire for years.
Absolutely.
I mean, we'd see smoke coming out of them as we drove up the turnpike, and fire at night, you could see it glowing. But you're saying none of these,
We do
none
not
of
have
these
any
fire
fire
in there.
going on, Your Honor, and I can guarantee you wouldn't have prosecuted us under the Refuge Act. And furthermore, I think you have some active role in the Refuge Act as well, that you do actually were depositing. Our folks are passive surface owners. And what we.
But you're claiming your client's got nothing to do with it. I mean, you don't own the property and the gob piles and the.
Right, we own property down there, sure, Your
But not
Honor,
this.
but where they were saying there's something bad, we didn't own that piece of property. We're near it, but we did not.
But did you get summary judgment on that basis?
Yes, sir, we did. We moved for summary judgment. Obviously, you know, when you bring a case, you have the burden of showing ownership. They failed to meet that burden. The court went through it in very detailed analysis, and ultimately, the pivot that the county did in our motion for summary judgment, they said, well, the 2003 deed, the operative deed, you conveyed some property, but you didn't properly reserve the tracts that are at issue. And that was the legal issue in front of Judge Johnston. And so Judge Johnston looked at the operative deed and looked at the conveying language, and it was clear and unambiguous that indeed we did accept certain tracts, what we refer to AML properties. That was, as a matter of law, reading a deed. And that's what the court did. The argument that somehow we didn't fully delineate and establish our property lines is not the issue. That it does not unwind the conveyance by parties to which the county is not part of. They're a stranger to it, so they don't even have standing to raise this issue. They raised it nonetheless. The court went through it in detail and said, no. Looking at West Virginia case law, the way in which property is conveyed in West Virginia is you clearly convey it, and the only way that you can somehow say that you didn't convey it is there's some ambiguity. It wasn't clearly conveyed or accepted, and it was done here. And for that reason, the court said summary judgment. And we got summary judgment, and then really the issue that was set forth in the appellate brief.
There was
Sorry.
there was a little argument about, well, maybe some of the pile is partially on tracks that weren't part of the reserved tracks. The district court seemed persuaded by plaintiff's own expert who said absolutely no one knows where these piles begin and end. Does that resolve that part of the issue?
That doesn't change anything, Your Honor. That's exactly what the court did. And again, when you talk about the gob piles, I think we have this image, and I agree with Judge King, that was the image I first had. It was some giant tower of coal refuge that was on fire at one time and so forth. That's not what we have. We have wooded hills in West Virginia. And what the court was saying with respect to Simonton, and the reason it said that's mere conjecture is, look, you got the burden of proof. Now you're coming in with an affidavit at the last second and say, we don't know where the refuge pile. I don't know how that helps their position.
Right.
It certainly doesn't help their
They have
position.
the burden, and the best evidence was
Right.
an expert saying, we don't know where they are.
Right, and that, to me, is just conjecture, and it reinforces the problem here. If you want to bring a case like this, the first thing you should do, the threshold thing you should do, is you make sure you get the right people. And then you test it and make sure it has an actual contamination at the level that you need. That wasn't done in either case. So for two separate reasons, we were dismissed, and we would ask this court to affirm that.
Were you dismissed or you got a summary judgment?
Well, we got summary judgment, and the judgment order dismissed
It's a
us.
final judgment. You won.
Yes, sir. Yes, sir.
Thank you, Mr.
Thank you.
McDonald. Mr. Lee?
Thank you, Your Honor. I'm here to talk about something no one's talked about yet, and I would describe it as the hanging chad in the case. That's why I've got 2 minutes. It deals with the insurers who have been sued in this case, and I represent Continental Casualty and speaking on behalf of the various insurer defendants. The insurers were sued by the county in a direct action. The county is suing another entity's insurers, EACC, who is a subsidiary of National Grid, and owned the land on which these piles sat for a period of time, didn't place the piles there, and doesn't own them anymore. But the insurers have been brought into this case by the county on a direct action. Let me give you several reasons why the grant.
How many insurance companies?
I think it's 8, 9, 10. There's a series of coverage over the years and so forth, and I represent one of the
For
carriers.
periods of time?
Yes, correct, Your Honor, correct.
So
So we have raised in our briefing several points. First,
when were these gob piles put out there, 1920? Is that what the record is?
I think it is the 20s, 30s, and 40s, but by 1950, it was over.
Yeah.
And so nothing happened, and so.
They quit mining coal up there on the Johnson Fork.
Yes, yes. So there's several problems, but I want to tell you about what those issues are, because I can only list
And
them.
a lot of people in southern West Virginia say they quit mining coal and left town.
That's certainly the case. I've done a lot of fishing in West Virginia, Western Maryland, and you can see it. But the fish are there because I catch one once in a while. The issues are several. First, they don't cite a single authority or a single record citation in support of their arguments, which are about 3 or 4 pages long. Secondly, the ordinance they've enacted gives themselves the power to bring a direct action against insurance companies when that's not allowed under state law. State law does not allow a direct action by a claimant against insurance companies, with several exceptions that don't apply here. Yet they enacted an ordinance that says that they can do it. That's unauthorized by law. But
Fayette County enacted the ordinance that
the ord-
authorized it.
Yeah, the ordinance they're relying
Yeah.
upon gave themselves the power to do something that they're not allowed to do. And the state certainly didn't authorize them to do it. The court listened to their arguments that because of the open dumping laws that EACC owned the land during, that somehow or another that would give the county the right to sue the insurance companies of EACC, which is the subsidiary of National Grid. So the district court heard the arguments and rejected them. The county argues that the district court just forgot about them or forgot about this claim, and the district court didn't. You can see it from the record. But there's a final point, Your Honor, and this is the...
Actually, this is not your problem, but we can't see it from the record because it was not included in the joint appendix, any of these rulings about the insurers.
Correct, it was not.
We can go find it, but that's against our rule. It's supposed to be in the joint appendix if it's being appealed.
Right, it was not in the joint appendix, you're right, and that's why, I guess, it wasn't cited to by the county. But there's a practical issue, and I think part of the reason for oral argument is to talk about practical things. Insurance companies, and they're also in the record, they're not in the joint appendix, but they're in the record because the county attached them to its complaint. The insurance policies, and this is not unusual at all, it's sort of uniform. Insurance policies provide coverage, indemnity coverage, for two things: bodily injury or property damage. There's no insurance coverage for maintaining open dumps. There's no insurance coverage, as Mr. Callahan said, for eyesores on the side of the road, tires or trash. There's insurance coverage for property damage, damage to tangible property, destruction of tangible property. Those are the words used in the insurance policy. What the county is saying is it wants to pursue EACC for maintaining an open dump. There's no insurance coverage. There's nothing in the policy that says we'll cover you if you get sued for maintaining an open dump. It says we'll cover you if you get sued because you caused property damage, tangible destruction and damage to tangible property. There's no proof of that. That's the whole point of this case. Given there's no proof of that, even if you sent it back to the district court, that's going to be the outcome. Because if you send it back because the county supposedly wants to put more evidence in, and it didn't get the chance to do so according to it, what evidence is that going to be? They put their evidence in about what they think happened. We've got a policy that says you have to prove property damage. They now want to argue that I can prove an open dump claim without proving harm. Maybe that's a problem for EACC, but and I don't think it is because EACC didn't put anything there. But it's certainly not a problem for the insurance companies because they only cover property damage that's right in the term of the contract.
It's putting something in the river that's not water. It's not property damage. you say?
Absolutely not, Your Honor. Property damage,
Well, in the Refuse Act, it says you can't put anything in there that's, except that flowing from streets and sewers and passing therefrom in a liquid state. Anything that's what the language of the U.S. Code says.
and I've carefully
Into
listened.
any navigable water of the United States or a tributary.
Right, and I've carefully listened to the discussion. I didn't know anything about the Refuse Act either. But that's a criminal law.
It is a criminal law.
For doing something.
And it says it shall be unlawful.
But it doesn't require damage. It
I'm
does-
just asking if that's not damage.
No, no. It would require another step to find out whether by
And then
doing
that-
something you were
and then
locked up.
And then indictment, it calls it black coal waste matter
Right.
into a tributary of the Kanawha River.
And again, as the prosecutor, Your Honor, you didn't have to prove that they damaged anything. You just had to prove that they did that.
Had to prove it was black coal waste matter. Well,
Right,
that's not-
right.
That doesn't sound too healthy.
Well,
For
Your Honor, and not
For
to
the
be...
people downstream that are using it for their drinking water.
Your Honor, not to be cavalier, I don't disagree with you. It doesn't sound too healthy, but the proof has to be there. And here, the chance was given to the county to prove that it was a problem, and they offered no proof. If you have no other questions.
How did they, what exception to the rule, you can't bring a direct action against the insurers? Did they
Generally, there's
cabbage onto?
There's two exceptions generally. If you seek a declaratory judgment as to whether there's coverage or not, simply a DJ, that's not sought here, okay? And then if you have a judgment against the tort defendant and the tort defendant doesn't pay it, then you can take that next step to seek to collect that judgment against the insurance policies at issue. That's not the case here. Those are the two exceptions.
And those
that-
exceptions don't apply here.
Not at all.
Okay.
Thank you, Your Honor.
Thank you, Mr. Lee. Mr. Donovan?
In our rebuttal, on behalf of the County Commission, we emphasize two incredibly pivotal points to this court. Number one, there is no requirement in West Virginia law that a nuisance has to be a nuisance at common law. That is an obligation in a judicial imposition of liability when two private litigants sue each other and ask a court to declare something to be a public nuisance. When a legislative body with the authority to do so declares by statute or by ordinance what is a public nuisance, that is a public nuisance. No common law requirement at all, as has been the law unquestioned in this nation since its inception.
You're talking about state law there.
State law, that's right, and the answer to
And all this, and y'all are arguing, boiling that down to state law, and we're not the experts in West Virginia state law.
But in this case, Your Honor, a federal court trying to interpret and apply that law has stated that it may use, that a ordinance declaring something to be a public nuisance is not enforceable because it's not a nuisance at common law. That is error. That is plain error. And they cite to you, and inappropriately, and that's the pivotal point here, Parker versus the city of, Parker versus the 1913 case, and then Sharon Steele, which is the later 1989 case. Or, yes, 89. Your Honor, the point here is, in Parker, the West Virginia Supreme Court said 2 times and very clearly, a public nuisance must be declared by statute, by ordinance, or by the common law. By statute, by ordinance, or by the common law. In Parker, they struck it down because the ordinance didn't declare anything. It was as goofy a situation as you might imagine. All the ordinance said is that the city may. Not the city did. It didn't find anything to be public nuisance. It merely recited the enabling authority. And the Parker court said that's inappropriate. To impose public nuisance by statute, it must be imposed by statute, by ordinance, or by the common law. They then take one sentence out of the 1980 decision in Sharon Steele, which I emphasize to this court was a question on facial validity of an ordinance, not as applied.
You all both are arguing Sharon Steele supports you.
I beg your pardon?
Both sides are arguing that Sharon Steele's on their side, right?
That's right.
You say it's on your side?
Absolutely it is. And the point they use, I'm saying, is one sentence. And the pivotal sentence in that decision, remembering that it was a facial validity attack, and the West Virginia, or the ordinance said, the permanent disposal of hazardous waste within the city boundaries is a public nuisance. And the question before the court, as that ordinance was attacked on facial validity, not any particular site or any particular thing, but the ordinance has a facial validity attack. And the court responded and said, a very extensive analysis of federal and state law, and noted that federal and state law have literally hundreds of pages of statutes and regulations governing hazardous waste. And the court upheld it and said that's a valid ordinance. But, of course, because it's a facial validity attack, they said when you get down to actually applying it to some actual facility or actual site, it has to in fact be a nuisance. It has to be what's declared to be a nuisance, either by statute, by ordinance, or by the common law. That's all the court said, one sentence. And it emphasized in that sentence it must in fact be a nuisance. Not at law, but in fact. Because it was a facial validity attack. They are trying to take that one sentence and have this court authorize a proposition of law that says when a legislative body declares something to be a public nuisance, it must also be a public nuisance at common law. That's not only absurd, it's an affront to the dignity of the legislative body that is the decider of what risk is acceptable to the public. West Virginia legislature has that authority, and it clearly delegated that authority to the county when it said anything that the county determines to be, the county commission determines to be a public nuisance may be abated. The point being here, Your Honor, that they're totally distinct concepts. What is a public nuisance at common law is an appropriate control on a judicial imposition of public nuisance. When private parties come before a court and say, please declare that to be a public nuisance, then the court properly should be bound by the common law.
Can I I don't want to cut you off here,
No.
but before your time expires, I wanted to see if you have anything to say about the insurer defendants, since that didn't come up
Yes,
in
Your
your
Honor, and you're-
opening. In the district court, it looked like the district court stayed the matter as to the insurers, and then it gave the parties 10 days to file any objections to dismissing the insurance claims after it had disposed of all the other claims. And the county commission responded to that and told the court to dismiss the insurer claims. That's the relief you sought, was dismissal without prejudice because there was just supplemental jurisdiction.
They
Is
have been
that, what do you want us to do?
The point being, Your Honor, that nothing was ever done on those claims. They were stayed from the very get-go. There was never any proof under them, never any proceedings, never any introduction of any evidence or argument before the court.
Well, it looked like the court gave you an opportunity to show how those claims would be different as to EACC, how the court's rulings had not already addressed all that. But instead of saying that, you said, please dismiss these claims.
No, Your Honor, the county responded to that with a filing before the court that said, EACC owned, maintained these piles after the effective date of the Solid Waste Act. So it's different than National Grid. EACC owned and operated and controlled those gob piles from 1966 through till almost 2015. The Solid Waste Act, federal and state, became effective in 1983. So
Well, I mean, I read your papers, even though they were not in the joint appendix, and even though the court's rulings on this issue were not in the joint appendix. I did find them and read them, and you say the dates of ownership were different, but please dismiss this for lack of supplemental jurisdiction. There was no explanation on any count 1, 2, 3, 4, 5, 6, 7, 8, 9, of how EACC is different from any of these other defendants. You did mention the timing probably is different, but you didn't explain why the court's rulings would not apply equally to EACC and to the insurers because
court-
of direct
Yes,
implications.
Your Honor, I think we did. The court's ruling was that the Solid Waste Act cannot be applied to National Grid because their ownership preceded the effective date of the act. EACC owned after the effective date of the act and maintained it. And we said in that very same filing, therefore EACC is totally different, but there's never been any proceeding against them. There's never been any chance to introduce proof or make any argument about the claim. The claim was stayed from the get-go. So
So you say there's no final resolution to that?
we said dismiss it without prejudice because we'll bring it again. But the point is,
Well, was it dismissed?
without prejudice, yes, Your Honor.
It was dismissed with prejudice, right?
No,
We have a
without
final-
prejudice, Your Honor.
you-
There was no prejudice in the final dismissal order of those claims.
Then why are you appealing if you got what you asked for?
I beg your pardon, Your Honor.
Then why are you appealing if you asked for dismissal without prejudice and you got dismissal without prejudice? What is there to appeal?
Well, the point of the order is, when the court dismissed, it was totally silent on the question of prejudice. The dismissal order is totally silent. The question is, can you attach prejudice? And that's why we appealed, to make it clear that you can attach prejudice to a claim that there was never any proceeding on. There was never any chance to even introduce evidence or argument or anything on that.
Maybe we don't have a final order that's appealable here.
Well, I believe that's probably correct, Your Honor. I mean,
Well,
maybe that,
then we're wasting our time.
as to the insurance
No,
claim.
as to everybody. You have to have a final order that disposes of the case before you can come to Richmond.
Yes, Your Honor, and
And so
there's
that case, the case against that has to be final, as to every aspect of the case.
and there is a dismissal order that applies to National Grid, and that dismissal order, as on its face,
It's gotta be final.
it is a final dismissal order, yes, Your Honor, but it's silent as to the question of prejudice. It doesn't say dismissed with prejudice, it says they're dismissed. Obviously, we believe the claims against National Grid, prejudice attaches because there was the introduction of evidence, and there was argument, and there was proof, and the court considered it and disposed of it on summary judgment. Not so with the claims against the insurers. There was no proof, no pleading, no argument, no introduction of evidence, no anything. They were stayed from the get-go and remain stayed throughout the
Do
entire
you
case.
concede right now that it's dismissed, it's over with?
I beg your pardon, Your Honor.
Do you concede that part of the case is
The claims against the insurers were dismissed without prejudice, yes. And I mean, I don't think there's any other way to interpret that order, because the only other way to interpret why we appealed, Your Honor, is to make clear that prejudice can't attach to that claim because there was no proceeding on it. I mean, there was no chance to even introduce evidence or argument or do anything. It was stayed at the beginning of the case and remained stayed to the final day. There were no rulings by the court on it, no decisions about it. It was just, it was that, stayed from the get-go. So,
Again, if we had the orders, we would be able to look at the joint appendix and talk about this. But the district court ordered it stayed, and then it gave you an opportunity to show why it shouldn't be dismissed with prejudice with all the other claims, and found that that was not shown, and then the court dismissed all the claims and closed the file. And we have background rules about what to imply if the final order is silent. But there's a question about whether this is even properly appealed because of the violation of the appellate rules of not including these orders.
no, well, Your Honor stated that the court gave us a chance to prove why it shouldn't be dismissed with prejudice. It did not ever use the word prejudice. It said why it should not be dismissed.
Can you show me in the joint appendix where that is?
It's in the final order.
Where, I mean, in the court's order saying it's going to lift the stay, where it uses the words with or without prejudice?
It doesn't. It says.
But where in the joint appendix can I find that order and whether it uses those words?
I don't have that number available.
It's because it's not in there. And we have a rule that if you're going to appeal an order of a court, you have to include it in the joint appendix.
Yes, Your Honor. I understand the court, what the court is saying. That, again, the court put out an order and said why these claims should not be dismissed. Didn't say dismissed with prejudice or why, without. It said why they should not be dismissed. We responded and said, Eastern Associated, the claim against the nominal party Eastern Associated, has never proceeded before the court. It's been stayed from the get-go. If it's going to be dismissed, it should be dismissed with prejudice, or you can refer it under supplemental jurisdiction, send it back to the state court. But the point being that there was never any proceeding on it. I mean, that's how we responded to the order, but the court's order to us was why it should not be dismissed. And we responded by saying, well, as a national grid, that's, of course, a lot to say about that, but as to EACC, there was never any proceeding. So, I mean, if you're going to dismiss it, it would have to be without prejudice, or you could simply, decline supplemental jurisdiction over it and send it back. But the point being that the order to us wasn't why it should be dismissed with or without prejudice. It was just why it should be dismissed. And that's what we responded to by that filing. So the court makes I'm assuming that the court is saying we didn't attach the order in the appendix. And if that's true, that certainly is an error. And but that's what happened. The court did not say with or without prejudice in its order, just why should they not be dismissed? And the point we made was, as the EACC, as to the county's claims against the nominal defendant EACC, there was never any proof, never any proceeding, nothing ever happened. So dismissing it, any concept of dismissing it with prejudice would be inappropriate because there's no basis for doing that, right? And to say that.
Thank you, I understand.
Okay. Thank you, Your Honor. Appreciate it.
We very much appreciate counsel's arguments, and we'll take the matter under advisement. We'll come down and greet counsel, as we do in a matter of tradition here, and then we'll take a short break. Come back and finish for the day. In our next case, we have 24-1658, Dr. Fernandez versus Mr. Britch. Let's see here, I gotta get my cheat sheet. Mr. Kuntz? Yes, Your Honor. Good to have you with us.
Thank you. Good morning. May it please the court, my name is Brian Kuntz, and I represent Dr. Fernandez in this matter. This matter arises from the Virginia Department of Transportation's refusal to issue a determination as to the vast majority of relocation claims that he submitted as a result of having to relocate his dental practice due to a VDOT road project. Specifically, this is an appeal from the district court's denial of Dr. Fernandez's motion to amend his complaint with regard to his equal protection claim. The district court erred in holding that he was required to apply a heightened and inappropriate pleading requirement with regard to similarly situated comparators. The district court relied on this court's decision in the SAS Associates 1 LLC versus City of Chesapeake matter and held that Dr. Fernandez was required to show an extremely high degree of similarity between the similarly situated comparators and himself. The issue being, though, that the district court applied that matter, though this court went out of its way in its holding to find that that was an exception to the general rule of pleading when it comes to equal protection classes of 1. This court specifically recognized that that heightened standard applies to cases such as zoning decision cases that was the subject of that case. The court went as far as to distinguish it from other class of 1 equal protection claims in discussing the Supreme Court's holding in Village of Willowbrook v. Olick and the cases that it relied upon. In that case, the standard that the court was distinguishing requires the showing that the government unequal treatment is governed by a clear standard by which departures, even for a single plaintiff, can be readily assessed. And that's the appropriate standard that should have been applied in Dr. Fernandez's case. The increased standard under SAS Associates applies to cases like zoning decisions in which it requires an extreme factual analysis and a broad range of discretion to the local governments who are applying those decisions. For instance, in zoning decision cases, facts such as the size of the parcel, public infrastructure, road frontage, all these types of issues go to the weight of the decision that the local government made with regard to approving or denying a rezoning. To compare oneself and claim unequal treatment under a zoning decision, one must show that those comparators are similarly situated to an extremely high degree because decisions can be based on those factors. Here, however, the clear standard under Dr. Fernandez's case is a simple yes or no question. Was a final determination issued regarding the relocation benefits that he submitted? There is no discretion to the Virginia Department of Transportation or appellees whether to approve or deny or whether he's entitled to a determination. In fact, the law requires that once the
Well, they gave him one determination, right? There was a determination on part of his request, and they gave him money, and they gave him a letter, a notice that said, you can appeal this. This is a, I don't know if it uses the word final, but this is an appealable decision.
Certainly, they approved $255 for Dr. Fernandez for his time spent searching for a new location. That's one.
And is that, how do we know if other people are similarly situated? What's our comparator for receiving a determination and money, but not all of the money or all the determination?
Well, the comparator are anyone who is displaced. And Dr. Fernandez's claim is not based on the amount of money that he's received or not received. There is discretion and a factual analysis as to the amount of money that a displaced person is entitled to receive. There is no discretion with regard to whether the agency, the state agency, in this case the Virginia Department of Transportation, is required to provide a determination or not. And that's the difference between SAS Associates 1 LLC and Village of Willowbrook v. Olick, which this court distinguished it from. And so the similarly situated comparator, as Dr. Fernandez pointed out in his complaint, are those who were also relocated and displaced as a result of the same VDOT road project. And the difference is those people would have received final determinations, whereas Dr. Fernandez, in his complaint with the factual allegations that he's alleged, has proven he has not received that final determination.
But he did receive a final determination.
He received, Dr. Fernandez submitted over $500,000 worth of claims for reimbursement. He received, with that letter that VDOT contends is a determination as to his entire submitted complaint or claims, was a final determination as to the $255 of search reimbursement.
How does that compare to these other folks?
The other folks have received final determinations as to their entire submitted complaint or claims, whereas Dr. Fernandez, due to discriminatory animus, has been withheld the final determination.
Where's that in your proposed amended complaint, that they received it as to the full amount that they requested?
He alleges that he was treated differently from others who were similarly situated in not receiving a final determination.
And you're suing only in official capacity.
Correct, Your Honor.
You've got a 11th Amendment problem there.
No, Your Honor, respectfully. Under the 11th Amendment, in official capacity under the Ex parte Young decision requires a allegation of an ongoing harm, an ongoing violation, and prospective relief, and that's exactly what Dr. Fernandez has alleged and is seeking.
But you want money.
No, he wants a final determination, Your
You're
Honor.
not wanting any money, okay.
Right. The requested relief is to order an injunction and enjoin VDOT from withholding the final determination that they've done for now the past several years.
Well, so that's you're claiming a denial of equal treatment that has already happened. Other people have received this determination. He was denied it and treated unequally at some point in the past.
It's an ongoing denial of equal treatment. Dr. Fernandez has alleged in a discussion with the Chief Deputy Attorney General that he was told that VDOT did not consider his claim a priority and a final determination would not be forthcoming. And so it's the ongoing refusal to provide a determination that is the subject of his equal protection claim. And so that's going back to the similarly situated comparator, unless there's any other questions on the 11th Amendment issue. The heightened pleading standard that the district court imposed goes beyond the requirements here, and I think we have to look.
So what standard do you, what is your position, the standard that the district court should have used?
Certainly.
No comparators?
No, the general rule for surviving a motion to dismiss for an equal protection claim requires the pleading of facts to demonstrably show or plausibly that he was treated unequally from others who were similarly situated, and it was due to discriminatory animus. The facts that Dr. Fernandez has pled have shown the unequal treatment. He was told by another deputy district attorney general that had he not engaged counsel and sued to pursue his rights, that he would have received not only a determination, but a positive determination and would have received more money. So that's the discrimination that he's alleged.
But how is that, I mean, but where are the similar comparators? You have to, I think you would have to make an argument that somebody else that did not do as he did also did receive additional.
Certainly, and we did allege that, Your Honor.
But who are the similar
Well,
comparators?
Everyone else who was relocated as a result of this project. The burden of pleading at this stage, at least at the 12B6 stage, is not to name or identify by name similarly situated comparators. And the appellees even agreed with that and went so far as to state in their brief that the district court didn't even use the word name once in his opinion. And so what Dr. Fernandez has pled at this point is that it's plausible that he has been treated differently from others who were relocated not as just a result of this project, but other road projects, and been denied the final determinations that he's entitled to as a result of being relocated and submitting his claims.
When does the statute, when does a final determination happen? It looked like you can appeal, and then after an appeal, a determination is considered final, from best I could find, but what's your interpretation?
Sure. Under 49 CFR 24.207, I believe, it requires an expeditious review of all submitted claims, an expeditious review and determination of all submitted claims. It doesn't give.
Those are claims specifically related to relocation for highway construction?
Correct. Yes, relocation as a result of the road project that necessitated the destruction of his practice. Doesn't give an exact time frame, though, to address your question, Your Honor. It just says an expeditious review and determination. And based upon the pleading that the Deputy Attorney General said that no determination would be forthcoming, and that VDOT did not consider his claims a priority, that is clearly a violation of the requirement of an expeditious review and determination. And so, looking at the basic requirements for a motion to dismiss an equal protection claim, Dr. Fernandez not only meets that burden, but clearly exceeds it. He has pled plausibly that his rights have been violated and that he's been treated unequally from those similarly situated.
Judge Jackson said that it was futile to file it.
Correct. Correct. At this stage as well, too, that it couldn't meet the standards under a 12b6 motion, and that it was futile to proceed. And I think it would be also helpful to look at a case that the appellees cite in their brief as well. It's a Second Circuit case. I know it's not controlling here, but the case, Seventh Circuit case, Labella Winnetka Inc. versus the Village of Winnetka, which talks about similarly situated comparators being pled, that they have to be similar in all material respects. And that's the issue here as well, too. In all material respects is simply that a person is relocated and displaced as a result of a road project. And that's what Dr. Fernandez has pled, that he is being treated differently from those who were similarly situated and relocated as a result of that. If there's no more questions, I'll save my time for rebuttal. Thank you.
Thank you very much, sir. Mr. Pops?
Thank you, Your Honor. Good morning. May it please the court. My name is Stephen Pops. I'm the Chief Deputy Attorney General of the Commonwealth of Virginia, and I'm lucky to be joined by the Solicitor General of Virginia, Erica Maley, with me today. And it's a pleasure to be before the court on behalf of the appellees, Stephen Britch and Lori Snyder. This court should affirm the district court's rulings for two reasons. First, Fernandez's motion for leave to amend is futile. The proposed second amended complaint asserts a class of one equal protection claim. However, it fails to identify any comparators with sufficient detail to permit this court to determine whether those comparators are similarly situated to Fernandez. It also fails to allege that Fernandez suffered discriminatory treatment that was not justified by at least a rational basis. The proposed second amended complaint, therefore, would not survive a motion to dismiss. Second, the 11th Amendment bars Fernandez's backward-looking equal protection claim. Nothing in the proposed second amended complaint brings it within the ex parte Young exception to sovereign immunity. It does not seek prospective equitable relief from ongoing violations of federal law. For those reasons and the reasons in our brief, we ask that this court affirm the district court's opinion, and I look forward to any questions that the panel may have.
What's your response to this argument that past action by the state in granting other people a determination, but not granting the plaintiff determination constitutes an ongoing equal protection violation for purposes of ex parte Young?
I disagree with the argument, Judge Rushing. I think that the June 15th, 2018 letter, which is in the joint appendix at 856 and 57, makes very clear that that VDOT made a determination as to the claims that were submitted by Fernandez. It specifically states that if Fernandez is not in agreement with any of the determinations made, that he may file an appeal in part or in whole within 90 days of the date of that letter. And Fernandez chose not to do that. Instead, he chose to file a state court claim, which was dismissed, and then a federal court claim, which was also dismissed. So the record and the allegations all show alleged action that has already been completed. There is no prospective harm. to the extent that Fernandez argues in his brief that the interest payments that he took out are an ongoing harm that clears the ex parte Young burden, we disagree with that contention as well, because the interest payments that he took out are a consequence of an alleged past harm that he suffered, not an ongoing one.
What about these supposed, about these conversations with other people in this, in DOTs, who they say things that give an impression that maybe there's still something that could be decided later? If you send us some more information, does that change the analysis at all?
I don't think it does, Judge Rushing. I think that all of those responses by DOT, by VDOT, were responses to outreach from Fernandez. And as a state agency, VDOT tries to be responsive to citizens when they communicate with them. The fact of the matter remains that the record is replete, and the joint appendix is as well, with repeated communications from VDOT seeking more information, more support from Fernandez for all of the claims, the dollar amounts that he submitted. And the record demonstrates that he did not submit those claims. And the 49 CFR Part 24, which was referenced in my colleague's argument, actually requires that all claims must be submitted within 18 months after the displacement date. And so even taking the most generous reading, that time had long passed by the time that these subsequent conversations happen, or letter and email communications happen.
Do we have to address ex parte Young, or could we address only the futility of the amendment? Would that resolve the case entirely from your perspective, or are these sort of independent grounds that you identified at the beginning of your argument, or are they both necessary grounds?
Yes, Your Honor, they're independent grounds. The court may address either of them or both of them, but I don't believe the court needs to address the 11th Amendment argument.
Like normally we would do that first, right? But not necessarily a requirement?
I think so. I think that's right, Your Honor.
That statement that somebody supposedly made, or they alleged was made, that's pretty rough, though. About criticizing him for hiring a lawyer in the middle of the case.
I think those are allegations, Your Honor, and I think that they reflect the cold factual reality of this case, which is that Fernandez received a written determination on June 15th of 2018, apprising him of his rights to appeal and the time by which he had to do so. And instead of doing that and filing an appeal with VDOT, he chose to pursue two failed state and then a federal lawsuit. And I think that those alleged comments, which happened 4 years after the time for which he should have appealed, simply reflect that reality, that there was a process by which he could have availed himself, and Fernandez chose not to do that.
Let me ask you about this argument of that the lower court uses heightened standard. And I asked earlier, what would you, how would you detail how he's supposed to, I guess, imply who the similarly situated comparators are?
Judge Benjamin, I think that the SAS Associates case is instructive in this regard, and in that case, this court held a little bit more than a year ago that a plaintiff alleging a class of 1 equal protection claim has to show an extremely high degree of similarity between his circumstances and those of his alleged comparators. Now in SAS, the plaintiff alleged 10 comparators, and this court still found that that was insufficient as a matter of law. In this case, Fernandez has not alleged any comparators at all. Fernandez has alleged that the comparators are other displaced persons along this project and similar projects. And that absolutely fails as a matter of law, and it fails under this circuit's precedence.
But I think he also makes his argument that, well, he doesn't, because the court wouldn't allow him to have discovery as to this issue, he, therefore doesn't, I guess the information is not readily available to him, but that you all have the information, and because he cannot have discovery, then therefore he was not able, I guess, to name his similar comparators. I'm curious to hear your argument or response to that.
Thank you, Judge Benjamin. My response is that one of the bedrocks of federal practice is you have to have a good faith basis to allege your complaint in the first place. And if Fernandez did not even have a single comparator to allege in his complaint, much less the 10 that the plaintiff and SAS Associates did, that is not a question for discovery. That is a threshold question and perhaps raises other questions about the sufficiency of the pleading in the first place. If there are no further questions, I thank the court for its time and ask that it affirm the ruling. Thank you.
Thank you very much, sir. Mr. Coons?
Thank you, Your Honor. To respond to my opponent's arguments, I would first like to address his claims that the June 15th, 2018 letter that Judge Rushing, I think, mentioned before is a determination as to the entirety of Dr. Fernandez's claims. And VDOT's own actions after that letter, after sending that letter, belie its arguments here today. Just 12 days later, on June 27th, 2018, and that's at 1376 in the joint appendix, VDOT sent another letter saying that to continue its review, it needs more information to move forward. That in and of itself is an admission that VDOT did not consider that June 15th, 2018 letter a determination in an appealable instance. Then the fact that they consider to continue to consider the information provided after the state Supreme Court case goes on to show that they also did not consider that June 15th, 2018 letter a final determination. So the fact that the only claim that was addressed in that letter was a $255 claim and a request to keep going and to keep providing information shows that no final determination has ever been made on the bulk of Dr. Fernandez's claims.
So you're saying you would have no equal protection claim? This appeal would go away if VDOT sent the dentist a letter saying everything is denied?
Absolutely.
He would be satisfied.
Your Honor, that's what we've been
But because
asked.
instead they've said, well, try to prove, give us some more documents, there might be a chance that that's the equal protection claim.
Well, the equal protection claim is that we've submitted everything that they've asked for. We've submitted everything that they asked for in 2021 and sent multiple follow-up letters to Appellee Snyder and received no response from them. Not the response saying we still need more information or we're considering this or anything like that. Complete silence. And then, of course, hearing from the Chief Deputy Attorney General that VDOT did not consider their claim a priority and no final determination would be forthcoming. That's the issue, and I think you're right. A final determination, whether everything was approved, denied, or somewhere in between would remedy the equal protection clause.
So if instead of saying, we don't, please send us more information, if instead they said, you haven't sent us enough information, denied, then he would be satisfied and this lawsuit would be dropped.
If they said they haven't sent us some more information, I'm not sure that would be it, because we've sent them everything they've asked for and they've.
Well, your equal protection claim is about you want a determination.
Correct, but that's
It seems that you would have to, your claim would disappear if they gave you a determination saying, no, we're not giving you any money.
I think that would then allow Dr. Fernandez to pursue the appellate procedures that Mr. Potts has mentioned in his claim that he's been unable to pursue because he hasn't received a determination.
But he didn't pursue those from the first determination?
Well, only under the $255. He did not object to that small fraction of a determination, no. And just to quickly address,
They offered you $255 and you were asking for $500,000?
yes, sir. Yes, Your Honor. But that was one cost submitted, or one claim submitted in a broad spectrum of costs that had to do with adjusting his new office space to a dental practice, moving personal property, all these types of things. That was only in relation to a separate claim, one individual claim he submitted for his time in searching for a new location. There's a broad spectrum of different costs that can be reimbursed, and that was one small one. And then just to briefly address the appellee's claims that for some reason Dr. Fernandez failed to submit his claims within 18 months. That has never been raised before. All of his claims were submitted well within 18 months, within 1 year actually of his relocation, and that has never been a defense or an issue that the appellees have raised before, and is nowhere found in the record. And then finally, Judge Benjamin, to address your question, to which the appellees replied regarding the heightened standard in SAS and how that should still be applicable, I want to actually read from the court's opinion when it talked about the Olick case and the general standard of clear standards by which you can depart from and have a readily accessible analysis. The court said, in contrast, discretionary zoning decisions such as the one here are generally not governed by the clear standard. To establish a class of one claim, a person complaining of a zoning decision must therefore show an extremely high degree of similarity. And so the court was clear that that extremely high degree of similarity in that case was specifically to zoning decision cases, which require a much higher factual analysis because the differences between the comparators are not as easily ascertainable and subject to a factual analysis and discretion. Thank you.
Thank you very much, sir. We will adjourn court for the day, Madam Clerk, and we'll come down and greet counsel and wish everyone the best.